Well, let's turn our attention to the Allahabad High Court that has triggered massive debate and outrage actually. A PIL has been filed in the Supreme Court. The jurists are seeking the Supreme Court's intervention. In a case involving an attack on a minor in Uttar Pradesh, the Allahabad High Court had actually ruled that actions like grabbing breasts or snapping a pajama string does not constitute rape or attempt to rape, but can be considered aggravated sexual assault, a comparatively less charge. In an order that has drawn sharp criticism and even calls for the Supreme Court's intervention now, the Allahabad High Court draws a distinction between the preparation stage and actual attempt in case of rape allegations. We have reactions from legal experts like Karuna Nandi, Pinky Anand and Indira Jaising lined up for you. Listen in, followed by Nupur's report.
This judgment has a huge number of problems, and you know, someone was asking me because of this judgment, should there be more women in the judiciary, etc. It's not the point. The high courts are constitutional courts, and at the very least, they must follow the law. The law is very clear. When there is a complaint of sexual assault or rape, then there is absolutely no question of requiring the victim to bring the evidence all together rather than requiring an FIR to be filed.
Ultimately, because of lack of, as we say, penetration, possibly rape may be a question mark, but attempt to rape, definitely. I don't understand how after, let us say, Mukesh's judgment, Nirbhaya's judgment, how can we in today's world actually envisage and make these kind of orders where we convert an entire situation into a travesty? I don't think we should be sitting and debating about this. It feels agonizing actually, that one has to debate about this. So I think we are very clear in our mind today, we will not tolerate such heinous offences being let off in this fashion.
We are witnessing really is some kind of backlash from the judiciary of this country when it comes to issues relating to women and more particularly violence against women. The judgment of the High Court of Allahabad which holds that a man groping the breasts of a woman, trying to strip her of her clothing, dragging her behind the culvert does not amount to attempt to rape. Well, then I don't know what else amounts to.
The Allahabad High Court has recently modified a summoning order and has held that actions such as grabbing a child's breast and breaking the strings of her pajamas and attempting to drag her to beneath the culvert before fleeing the spot do not amount to offence of rape or attempt to rape. Now, this particular order has sparked controversy and has sent shockwaves across the country. The court has in fact dropped the charges of Section 376 IPC, that is rape and punishment for attempt to commit the offence, attempt to rape, and of the POCSO Act. Now the High Court instead directed that the accused be tried under the lesser charges, that is Section 354B of IPC, that is assault or use of criminal force with attempt to disrobe, with intent to disrobe, and the POCSO section that is about aggravated sexual assault. Now what has sparked the controversy is that the very remark or the observation that has been made by the Allahabad High Court while passing this particular order and watering down charges against the two accused. There have been voices against this particular order saying that it can set a wrong precedent, and other courts can also in fact use this to grant relief to such accused. Now, what is the fact of the matter is that people are questioning that if the girl was actually taken to a secluded place, dragged to below the culvert by these two accused, they tried to disrobe her, they groped her inappropriately, and they only fled after people came to the rescue of the child and they reached the spot. Now, if they wouldn't have fled if the people would not have come to the rescue of the child, then what would have been their intention? So these remarks and these observations by the Allahabad High Court has in fact created shockwaves, and there are voices in fact from the bar also, senior advocate Kapil Sibal, Indira Jaising, all of them have in fact questioned that how can this order be allowed to continue, and in fact now a PIL has also been filed in the Supreme Court questioning this particular order, and has in fact sought the expungement of those observations which said that these lines that held that groping a child inappropriately, trying to unstring her pajamas, do not amount to attempt to rape or does not establish an intent of attempt to rape. So it will be important to see how the Supreme Court reacts to this particular order by the Allahabad High Court.